Hello, everyone. It's Lisa Patterson with Daniel Ravenel, Sotheby's International Realty in beautiful Charleston, South Carolina, and joined by Jennifer Flanagin of Case Law. Hey, Jennifer. Thanks for joining me today.
Thank you, Lisa.
Today, we're going to talk about property disclosures and how important they are. For people outside of South Carolina that do not have property disclosures, it's a form that you fill out with basically mechanics, things that you know about your house, everything from electrical to the roof to HVAC. You do that before you list your property. We include that in the multiple listing service. It's a very important document. You need to fill it out to the best of your knowledge because you don't want anyone to come back on you and say that you weren't honest on the document. Jennifer, also one of the big things that has been added to that this year, as you know, is if the property has flooded and if you've had any FEMA claims. And it's very important that people are honest with that one as well. So let's talk a little bit about, what happens if you don't know about something, or also what happens if you buy a property and you find out they did not fill it out to the best of their knowledge.
Yeah, so, the form we're talking about is the South Carolina Residential Property Condition Disclosure Statement. And there's a spot in the contract that the agents will mark whether or not the sellers will be or will not be providing this document. There are some exemptions where the seller is not responsible for providing this, and that's in the code section. Anybody can reach out to me. I'd be happy to go over whether or not your seller falls into one of these. Most don't. Most sellers are required to provide this document unless otherwise agreed between the buyer and the seller that they're not submitting it. But one of the exceptions that does happen is, a personal representative or a fiduciary of an estate. So if the property is being sold by an estate, the seller is not responsible for providing this, and that should be marked appropriately in the contract. And the reason you want to do that is because this is a legal document. And this is representing by the seller information about the property. And often, as a personal representative or a fiduciary of an estate, you're truly not aware of really much of the specifics of the property. I mean, if you look at the form, they're asking very specific questions. Problems caused by fire, smoke, drainage problems, of course, the flood claims, utilities, what kind of HVAC, that kind of stuff. And so, in an estate, you really may not know that information, so you're exempt. But otherwise, as a seller, this is a very important form. And in many states, sellers aren't required to disclose this amount of information, but South Carolina is different. We do have this form. We do require sellers to disclose all of this. And so it needs to be taken seriously by the seller. And whereas in the contract, there may be paragraphs that, you kind of skip over, kind of read quickly, you don't really need to pay attention to them, don't really apply in the situation. This is one of those documents you really need to go through with a fine-tooth comb, and you need to read every line of that they're requesting. And for example, some of the questions specify any issues affecting the property during your ownership. So, in cases like that, have you had any, for instance, problems with fire or smoke during your ownership, or problems with, any structural changes or room additions during your ownership? So those kinds of things, those kinds of questions you need to answer, even if the issue has been remedied. As a seller, you still need to answer those truthfully if you have or should have actual knowledge of those matters. And so as a seller, you do need to answer these honestly, as honest as possible. And you got three options. You have the yes, no, or no representation. And at least as you and I have seen and have talked about, marking no representation is a bit of a red flag to a buyer in most cases. And so as a seller, again, that's why you just want to really pay attention and really, really think about your answer. If you know there's an issue, or if you really have no knowledge, you don't have any knowledge, or you shouldn't know of any issues, then you can answer no. For instance, the roof system. Have you ever had any problems with the roof? You'd probably know that if you own the property, particularly if you lived in the property. And if you really don't know of any issues, then mark no. But if you do, even if they've been remedied, you need to disclose that. And, as attorneys, we always are big fans of disclosure. And I do want to talk about disclosure kind of as a separate topic after we kind of run through the initial stuff, because that's a whole separate thing. But, and when you're required to disclose, but if you know or should know, you need to answer honestly, and you need to disclose it. The buyer will appreciate it. And that's kind of the whole point of the form, is to go into this with as much information provided to the buyer as possible. Now, on the flip side, on the buyer side, I will say, even despite this form, I would advise all buyers to just pretend like this form doesn't exist. Read it. If you have information on there, certainly pay specific attention to those issues that are marked. However, as a buyer, I would require I would do all of my inspections. I would do all of my diligence. I would act like I never got this form, and I would really, really do as much research as I need to do on that property. And obviously, if certain things are pointed out, I would ask my inspector to pay specific attention to those items. But it's, ultimately it's on the buyer. The buyer's going to be one who owns. And, you mentioned ramifications if the seller isn't honest. After closing, if the buyer comes to find out that, something that the seller didn't disclose is actually, was actually a defect in the property, it's an uphill battle for the buyer to, obtain some kind of judgment from the seller. The burden of proof is high. You have to, you have to essentially prove that the seller knew about it and intentionally lied or negligently lied. Maybe that may be a possibility depending on the suit. But it's an uphill battle, and your damages have to be fairly significant to make it worth it, because you're going to rack up attorney's fees pretty quickly. And so, at the end of the day, I've seen that happen. And the majority of the time, the buyer just has to say, it's just not worth it. It's easier for me just to go and fix it than to go back after the seller for, $2,000 or whatever. But that's why I always tell the buyers, it's your responsibility to make sure that this gets taken care of by you during the contractual diligence period. So that's my advice to sellers is be honest, disclose as much as possible, as much as you know or should know. And my advice to buyers is do your diligence, do the inspections.
So one of the things when I have sellers, so a couple different things, a lot of the questions on there, they're like, I'm not really sure like what kind of pipes I have or what type roof this is. And especially with some of the historic properties, my advice to them is, during the time you've lived there, you've probably had work done. You've had plumbers, electricians, roof people, different things. You can always call your contractors. They're happy to help, give advice, let you know what you do have. Save all your invoices when you have had work done, because not only for tax reasons, but it comes up as a very good point for disclosure, especially if you've had things done and the buyers have a lot of questions. Another big one I get asked from sellers is, this was an investment property. I didn't live in it. It was a rental. And I kind of look at it this way, because I own a lot of rental properties. You know what's happening, because your renters are going to call you anytime there's a problem with anything. So still disclose, be very honest about those things. And as you said, for buyers, the way I approach it with my buyers is, as you and I've talked about before, yeah, you have this information on this form, act like it doesn't exist, and really buyer beware. Make sure you're doing every type of inspection that you need to do. And I always attend the home inspections, even if the buyer can attend, and go over with the home inspector up front on the property disclosure form. Here are some things we really want you to pay close attention to. So it is up to the buyer to make sure they do their due diligence.
Absolutely. And your point about home inspections brings me to the disclosure issue about, how you can obtain this knowledge that you need to disclose on this as the seller. And it's by any means. So for instance, the home inspection report, that is, if you are provided with a copy of the home inspection report as the seller, then you are now aware of possible, issues that are brought up on this disclosure that you now need to disclose. And the same thing actually applies to the agents. So as the seller's agent, if you are aware and you are representing the seller, you are their agent. And if you are provided the home inspection report, now you need to make sure that the seller discloses those items on this form. And ultimately, this is the seller's responsibility. The seller is liable for these responses, but you as the agent, if you are provided the home inspection report directly, you have a responsibility to share that with your seller, who then has a responsibility to to disclose that on this form. So just be aware of that. If you do get a copy of the home inspection report, you may want to consider, not asking for it, or specifically asking not to have a copy, because then you're going to have to disclose that going forward. So, that's not just a disclosure for that transaction. If that falls apart and a new buyer comes in and you fill this out again, or you need to, then you're going to have to include that information. And if you already have the original disclosure that you filled out, and now you've gotten the inspection report and you see that there are some changes that need to be made, the statute requires the seller to promptly correct those. So
it needs to be entered in MLS. The agent needs it. So, and that's what I tell my sellers when we get these inspection reports back. It's better to go ahead and try to keep that deal together and hold it together and fix things and work with that buyer, because if, as you said, if it falls apart, they are going to have to disclose that moving forward. Which brings me to another point with sellers. I like to, at certain price points, above certain price points, is that they have a home inspection report done, or home inspection done, before we list the property, so that they can take care of anything that they find beforehand, instead of having a deal fall apart over. And sometimes it's just little stuff that people don't really understand, and you don't want a deal to fall apart over that.
I think that's great.
Another thing, and we spoke about this yesterday, I have a past client. She's not listing her property, but she's in a condo, 2 condo units. And she just had a major home inspection report done on the entire building. And she sent it to me just because she wanted me to have it. She wanted to ask me about a couple questions. Well, now that I have that report, if either one, and there's some issues, if either one of those units go on the market, I know that information. So if anyone calls and asks me about either of those units, I have to disclose what I know until I know that they've had those things repaired.
Right. That's right. Yeah. I mean, the knowledge requirement is known or should have known, and it doesn't matter what source you're getting that from. It's not direct. It's not like you had to be directly involved in the repairs or directly involved in the issue. If you have knowledge of it, whether it's direct involvement or from your tenant or from a home inspection report, whatever way you gather that knowledge, you have to disclose it. If you get it, you got to disclose it.
Well, that takes us to some of the flooding issues in certain areas of Charleston. I see disclosures a lot in MLS that do not disclose any flooding. And living downtown, and I walk during some of these occurrences with flooding, and I see people's stuff out on the street, or the HVAC ductwork torn out and put on the street. So I know water got in somewhere. And because I've seen that, and people ask me, I have to tell them what I know. And then it's up to us, if I have the buyer for that property, to really dig and do our due diligence to discover exactly what has taken place.
Yeah. And I think, and I was rereading this form actually yesterday. And so there's 3 questions specifically regarding flood. Flood hazard, wetlands, or flood hazard designations affecting the property. So are you affected by, a flood? Are you in a flood zone is basically what that's asking. Okay. Yes, that's easy. Anybody can look it up on the FEMA map. That's an easy one to answer. Flood insurance covering the property. Well, easy one to answer. Do you have flood insurance? Yes or no? Then the new one, which is any FEMA claims filed on the property, which again, you need to answer that honestly. You'll know whether or not you filed a FEMA claim. That's a very specific claim. That's a specific, requirement. So you can answer that. You can answer all 3 of those questions regarding floods honestly and not disclose whether or not the property was ever affected by flooding, which is a little bizarre. But if you go up a few questions, there's a question that says, which is kind of separate, which, I think, again, a lot of people maybe just gloss over and don't really pay attention to, but it's problems caused by fire, smoke, or water to the property during your ownership. And I think it's written a little confusing because it's not with the section, if you will, on flooding. So people may see that and just assume that it means a leak. And maybe that's what the drafters intended. I don't know. But if I were a seller and I see it just says water,
Yeah.
I'm going to interpret that without knowing what the drafters intended, and just reading it on the face of it. I'm gonna read it as any water, not just a leak from a pipe, but any water, and that would include flooding waters. That's how I would read it, because it's not specific in that area, and I do think it's a little confusing because of where the question is located, and again, it's not with the flood area, flood section, but it says problems caused by water. And so
most sellers that are being very honest about it, I'll see them, and down in the section, well, where you can make remarks, it'll say during Hurricane Matthew, Hurricane Irma, whatever, we had water intrusion or whatever. And
right
now we'll say, on that form, it just asks if you've had a claim with FEMA.
Right.
Now, when you fill that out as a seller, I'm going to tell you the first question the buyer has is how much was their claim? And they're going to be asking that, which brings me to another thing that happens a lot. And, I know it happens. Someone will get water in their house. They will have a claim, but then their contractor has said, oh, well, we can do this, this, and this while we're in here cleaning that up. And, next thing you know, they have a new kitchen, or they have all new floors, or they have all these stuff that really didn't need to be done, which makes their claim higher. So if you have a claim, keep that in mind, because when you go to sell your property, it's going to come up and it's going to look like you had a large claim. So you really need to keep separate what really needed to be done.
Yeah, and that's a good point, because that's not on this disclosure. So on this disclosure, you're not required as a seller to disclose the amount of the claim. But see, and that's why it's good to have an experienced realtor, because as an attorney, I would never know that, because looking at the legal forms, it's not required. I would tell if a seller asked me how to fill it out, I would tell them to fill it out as requested. Don't add any additional information, like the amount of the claim, for instance, is not asked. But it's good to know that it comes up in the real world, which I don't see that part of it very often. And so that is good advice for sellers, just to be aware of that. And I think keeping a paper trail and keeping your files organized is probably a definitely a smart move.
Exactly.
Yeah.
I can't think of anything else on there that really, if you read each question, you should know how to answer it. Other than just being very honest and open about it. I seem to find with my buyers, I work with both sellers and buyers, but if the sellers are honest and the buyers know what they're dealing with up front, and we have our inspections, and we really work with an inspector, explains things, and you can usually work through these issues. It's when people are not honest, we find stuff and they feel right up front people haven't been honest with them, they're trying to hide something, and then they put a wall up, and it's hard to get past that.
Yeah, absolutely. And yeah, I know. I think that's good. And, if anybody has any questions, buyers, sellers, agents, they can always reach out to me. I'm happy to, pass along, any advice or knowledge I have about this. And like I said, I think, the important takeaway is sellers, read this, be honest, disclose what you know, and buyers, do your inspections.
And beware.
Rely on those.
Buyer beware. Sometimes I think people do more research when they're buying other things than when they're buying a property. And yeah, it's kind of funny sometimes to watch.
Yeah. Well, and I know it's overwhelming, and I do, I've done it, I mean, it's overwhelming when especially when you're working with a lender and the lender is asking for a million things and your insurance guy is asking for a million things and
The closing attorney's asking for a million things.
your million things, and you feel like you're pulled in a million different directions, and then you're having to do your own research on this huge investment, and again, this goes back to, I think, one of our very first talks on this, is that the importance of having a good realtor.
Yeah, exactly. Have representation.
Yeah, your realtor is the one who's going to keep it all straight for you,
Yeah.
because it's hard.
And help you get all these inspections and make sure
Yeah,
you're getting the right
right.
inspections and things like that.
And like you said, if you can't be there at the home inspection, your realtor will be, and you want a realtor who's going to be looking out for your interests, and not, I mean, and to be there for the home inspection, for instance. I know a lot of realtors who don't,
I'm at
which is,
every single one.
yeah. Oh, I know you are. Yeah.
I attend every single one. And I mean, and sometimes these home inspections, I was just talking to an agent earlier today, and we were talking about one, it was a 5-hour inspection. I mean, they
Wow.
can be anywhere from 3-4 hours
Yeah.
to 5 hours or all day if it's a large property.
Yeah.
So, when I know that's happening, I block that time out. I'm there. If, we can FaceTime. If my client can't be there, I'm their eyes and ears there. I have a list of questions to ask the inspector based on things that we've seen or from the property disclosure, or just questions they have in general, to make sure those things are checked and double checked.
Yeah.
No, and working with good inspectors that will,
Yeah.
I have good inspectors too. They'll actually call my clients and walk through the entire inspection with them if they can't be there.
Yeah. That's really nice.
That's important.
It is.
I think that covers everything. If anyone ever has questions, you can give myself or Jennifer a call. And if you have topics that you want to hear about, just let us know and we'll get those done for you. So thanks, Jennifer. I'll see you soon.
Okay.
Goodbye.
All right.